Prince died without a will. That one fact set off years of delay, public probate proceedings, family claims, and expense. His estate was not governed by Texas law, so I do not want to confuse that point, but the lesson still applies here in Texas, and it is one I think many families miss. I'm Harvey Cox, a Texas estate planning attorney. In this video, I want to explain what Texas families should learn from Prince's situation, why delay can be costly, and why no plan often means the law steps in with one of its own. The first lesson is that a private life can become part of a public process. A lot of people assume their family affairs will stay private, but if a person dies without a plan, probate may be needed to identify heirs, appoint the proper representative, gather property, and work through the legal process. Court proceedings are not the same thing as a private family understanding at the kitchen table. That does not mean every estate becomes a media story. Prince was a celebrity, so his case drew unusual attention, but ordinary families can still find themselves in a public legal process they never expected. The second lesson is that delay has a real cost. People often think only in terms of who gets the property. That matters, of course, but delay matters too. While things are tied up, family members may be trying to handle a house, sort through financial accounts, deal with bills, gather records, and make decisions without clear guidance. That can create stress at exactly the time the family is already dealing with grief. The third lesson is the one I especially want Texans to understand. When you do not make a plan, state law makes one for you. If someone dies intestate, meaning without a valid will, Texas law controls who receives probate property. The law does not ask what the person probably intended. It follows the statutory rules. Sometimes those rules line up with what the person would have wanted. Sometimes they do not. That becomes especially important in second marriages, blended families, and situations where people assume everything will just go to my spouse or my kids will work it out. That assumption can be wrong. I also want to make one point clear. The lesson is not that every person needs the same plan. Some people need a straightforward will-based plan. Others may need a trust-based plan. Powers of attorney, medical directives, beneficiary designations, and title review may all matter as well. The right answer depends on the person, the family, and the assets involved. But no plan is still a decision. It is simply a decision to let default rules and court procedures fill the gap. So what should Texas families review now? Start with a few basic questions. Do you have a valid will? Are your powers of attorney in place? Are beneficiary designations current? If you own real estate, does title match your overall plan? If you have children from a prior relationship, does your current planning account for that? Do the people who would need to help you know where the documents are? And if there were a crisis tomorrow, would your family know what to do first? If those questions expose uncertainty, that is the right time to act. A good first step is my Texas Probate Risk Workbook. It can help you identify planning gaps before those gaps become a burden for your family. You can download it from the link on my right. If you already know you want a review of your situation, you can schedule a consultation here using the other link on my right. Prince's estate is a dramatic example, but the underlying problem is not limited to celebrities. Ordinary Texas families can also face delay, expense, court involvement, and outcomes controlled by state law when there is no clear plan. If you want to reduce that risk, start now while you can still make your own decisions and put your wishes in writing. Thanks for watching. I'm Harvey Cox, and I'll see you in the next video.